Case before us is Tillery Holdings LLC versus Judge Holdings LLC. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. And if you do plan to reserve time, please let me know, as I'll be keeping track of the time. The arguments are being recorded, so please keep your voices up and introduce yourselves. You should not use the names of children or minors or victims. I'm not sure that that will apply in this case, but if so, you could refer to them by initials or terms like the child. The judges have read your briefs, and we are ready to proceed when you are. And if the appellant would let me know if he would like to reserve time.
Thank you, Your Honor. Can everyone hear me okay?
We can.
Yes.
Okay. I would like to reserve 2 minutes of my time, please.
Very well. You may begin when you are ready.
Thank you, Your Honor. May it please the court, Stephen Dodd, on behalf of the defendant appellant Tillery Holdings LLC. Parties in this case are Judge Holdings LLC and Tillery Holdings LLC for ease of reference. They're both Ohio LLCs, but I will simply refer to them as Tillery or Judge during the discussion. As the court's already aware from the briefing here, the underlying fact pattern relates to a contract for the sale of 3 self-storage facilities in Lorain County. Contract price was a total of $849,000. At the end of the day, Judge was the buyer. Tillery refused to close on the transaction. It is our opinion, as we have asserted in the trial court below, Tillery at the end never intended to close because it realized it made a bad deal. Contract was for $849,000. Immediately after Tillery refused to close, the 3 properties were listed for sale for $1,500,000, and they were sold by Tillery shortly thereafter for $1,405,000. The arguments that we have asserted on appeal can be essentially put into 2 different categories. The first being discovery issues for which the court utilizes an abuse of discretion standard on review. The second relates to summary judgment, on which this court applies the standard of review, which is de novo. In connection with the first category, to sort of oversimplify and summarize them, the appellant asserts that the trial court did not allow the discovery to proceed fairly and evenly. The trial court failed to rule on any of Judge's discovery motions. The trial court failed to rule on Judge's 56F motion and failed to allow Judge to fully conduct discovery, in particular, depositions of the plaintiffs and its 2 individual representatives. To summarize the argument with respect to summary judgment, the appellant asserts that the trial court misinterpreted the contract, that the trial court stopped reviewing the facts before it, and instead of construing the facts most strongly in favor of Judge, which it is obligated to do under Civil Rule 56, it in fact did the opposite. With respect to discovery, the overarching suggestion in our briefing is that there were a lack of consequences, and I would assert that was followed by very predictable behavior. One of the last things I said to the court in a filing I made, it is on the docket as number 63 for reference. I was opposing the plaintiff's motion after they had left for Bermuda to conduct depositions by video conference, at the conclusion of which I said, plaintiff and John and Jennifer Tillery should be ordered to appear in person for depositions. To do otherwise would only reward them for their outrageous conduct in this case and send a clear message that there are no consequences for anything. As you look at the trial court docket in this case, contrast what happened with discovery motions filed by Tillery with what happened with discovery motions filed by Judge. Tillery filed a motion to compel, for example, on September 21st, 2020. It is docket number 46. Trial court ruled on the motion less than 2 weeks later, on October 8th, 2020. That is docket number 49. We filed our first 2 motions to compel with respect to 2 separate sets of discovery requests. I would note that Tillery did finally respond to those 2 separate requests, but it took him 11 months to do so. Regardless, both our first and second motions to compel were never ruled on by the court, and there were no consequences. In August of 2020, the trial court ordered the parties to participate in mediation and ordered them to appear and participate in mediation. Tillery went on vacation. The mediation was canceled. There were no consequences. We filed a third motion to compel. The trial court never ruled on that motion. There were no consequences. The third motion to compel related to Tillery's failure to appear for a deposition of the plaintiff entity. We filed two motions for orders to show cause relating to subpoenas I served at John and Jennifer Tillery's home for them to appear for depositions. They didn't appear. They filed no motions. The trial court never ruled. There were no consequences. We filed a fourth motion to compel with respect to another set of discovery to which Tillery didn't even bother to provide written responses. The court never ruled. There were no consequences. Partway through the case, towards the end of it, we learned that the remaining 15 pieces of investment real estate that Tillery Holdings owned in Lorain County had been transferred for $0 to 5 new LLCs set up by Mr. Tillery. We served subpoenas on the statutory agent for those 5 LLCs. No responses were received. We filed a motion for an order to show cause. The trial court never ruled. There were no consequences. We filed a fifth motion to compel and requesting an order to compel and orders to show cause regarding a second no-show after a noticed deposition and 2 more subpoenas. The court never ruled and there were no consequences. We filed a 56F motion after plaintiff filed its motion for summary judgment with Mr. Tillery's very lengthy affidavit attached to it. The trial court never ruled on that. Discovery was not balanced. We have pointed out in our appellate brief the applicable standard of review and have cited to 8 separate cases in which courts of appeal, including this one, have found an abuse of discretion on facts similar to this, and in fact, much less significant. In connection with the summary judgment portion of our argument, the trial court has an obligation in construing the contract to simply apply it as it is written and give effect to the parties' intentions as they are written in that contract. What are the parties' intentions in a purchase agreement? It's to consummate the sale, finish a transaction relating to the sale of some property. In terms of the competing summary judgment motions and the trial court's ultimate ruling on summary judgment, there was no dispute, and the trial court agreed that my client breached the contract by not closing on time. There was no dispute, and the trial court agreed that Tillery had to provide a written notice of default under Section 7A of that contract. There was no dispute, and the trial court agreed that Tillery did provide that notice of default on September 4th, 2018. There was no dispute, and the trial court agreed that Judge had 30 days under the contract to cure the default, and that time ran to October 4th, 2018. On pages 4 to 5 of the trial court's ruling on summary judgment, it said, quote, "By the terms of the agreement, Tillery was required to send written notice of default to Judge and provide a 30-day cure period to cure any default," end quote. The trial court, however, concluded that since Judge did not deposit funds to close, that it did not cure the default. The trial court's conclusion, however, is inconsistent with the contract itself in 2 ways. First, it ignores the balance of the contract, in particular 3 sections. Section 5C, as in Charlie, of the contract, relates to what both sides must do in connection with any closing. Section 7A, as the trial court noted in its ruling, provides that Judge had a contractual right to cure. The contractual right to cure would be an illusory opportunity if the other side didn't have the obligation to participate and allow that cure to take place. And Section 8I. Section 8I of the contract is what I would call generically a cooperate clause. Section 8I required that prior to, at, and after closing, both sides had a contractual obligation to cooperate with each other in order to consummate the transaction anticipated by the contract. The trial court ignored that. Finally, the trial court ignored the facts. In the briefing below and in the brief here, the appellee asserts that there was no evidence before the trial court that suggested that Tillery did anything to prevent Judge from curing the default and closing the transaction. In fact, the opposite is true. The affidavit filed as docket number 114. Exhibit 4 to that affidavit is an email exchange between Tillery and the title company. That email exchange was not produced by Tillery in discovery, by the way. It was obtained by us from a third party. After I had sent emails and letters to both Tillery and the title company within the 30-day cure period, identifying the fact that Judge was now ready, willing, and able to close within the cure period, Tillery responded to one of those emails within that 30-day cure period and said, "We have no intention to close at this point." He didn't send that email to me. He sent it to the title company, to which the title company responded approximately 10 minutes later, just to Mr. Tillery, "We still have this file open, waiting for instructions. Would you like me to continue holding it open, or is it a dead deal?" Regardless of whether or not there was any further exchanges between them, the point is the title company never proceeded with the transaction. The title company would not send us a HUD statement, which identified how much money allocated back and forth per the purchase agreement we were required to deposit in order to close. We can't perform if the other side will not allow us to perform. Our argument was that Tillery had a contractual obligation to allow a cure to take place. The trial court agreed with that. The trial court ignored the fact that Tillery breached that contractual obligation and refused to allow us to cure within the cure period. At the end of the day, our brief requests that this court do one of two things. First, reverse the judgment of the trial court and, under its de novo review, enter judgment in favor of Judge against Tillery on Judge's cross motion for summary judgment, remanding for the sole purpose of the trial court conducting a trial as to Judge's damages. Or, in the alternative, reverse the judgment of the trial court and remand to the trial court to rule on the pending discovery motions, permit Judge to conclude discovery, including depositions, and then proceed to trial in the ordinary course. Thank you.
Thank you very much. You will have 2 minutes and 44 seconds for rebuttal.
Thank you.
Mr. Lane, when you're ready.
Thank you, Your Honor. May it please the court, Howard Lane, on behalf of the plaintiff appellee, Tillery Holdings. I would like to address Mr. Dodd's comments with regard to the Civil Rule 56 motion. First and foremost, the court should recognize, and the argument was made in our brief, that prior to the summary judgment motions being ruled upon, the parties entered into a stipulation with regard to the discovery motions that were pending, both filed by the defendant and the plaintiff in this case. Those stipulations filed in the trial court on March 4th, 2022, reveal that really there were only 3 motions that were left pending at the time that the summary judgment was ruled upon. That being the 3rd motion to compel filed by Judge Holdings, the Civil Rule 45 motion filed by Judge Holdings, and the 5th motion to compel filed by Judge Holdings. The Civil Rule 56F motion that Judge filed only addressed the 3rd motion and the 5th motion to compel. Those motions sought a order compelling the Mr. and Mrs. Tillery to submit 2 depositions. The first deposition round was scheduled in December of 2020. and the second being, or 21, and the second being in July of 2022. With regard to the December motions to compel, this is the third motion to compel that they filed. Again, the depositions were scheduled by Judge Holdings on December 3rd, 2020 and December 4th, 2020. Former counsel for Tillery Holdings had advised counsel for Judge Holdings prior to the scheduling of those depositions that the Tillerys had gone to Bermuda in an attempt to evade the COVID virus. And it specifically indicated that they had children that, because of their medical conditions, were specifically susceptible to complications that might arise from COVID. So they knew in advance, before even scheduling those depositions, that the Tillerys were not personally available to attend a deposition. Despite that fact, counsel for Tillery had offered to make them available for videotape depositions, where Judge Holdings counsel could have obtained whatever information that they wanted. Now, I understand that he may have preferred an in-person deposition, but during the height of the COVID scare, it was not uncommon for depositions to be taken by way of videotape. That offer of videotape depositions was not responded to. So the next day, he had filed his motion to compel, and essentially by scheduling the depositions, knowing that these people were not available, he was manufacturing a discovery dispute when he didn't have to. On top of that, the court had entered an order delaying all jury trials in its court until March of the following year because of the COVID scare, which would have given him ample time to personally depose them when they came back from the U.S. prior to trial. With regard to the fifth motion to compel, that had to do with depositions scheduled for July of 2021. Those depositions were noticed on July 16th, less than a week before those depositions were scheduled, and required a personal appearance in Mentor, Ohio, even though that the case was pending in Lorain, County, Ohio. In addition to that, at the time prior to the scheduled depositions, counsel for Tillery Holdings contacted counsel for Judge Holdings, explained that he had just inherited the case from prior counsel and needed additional time to prepare for those depositions. He agreed, and there was an agreement to delay those depositions until such time as counsel became familiar with the case. So the fact that he's filing a motion to compel for failing to appear on a date where it was agreed that the date would be continued is inexplicable. Beyond that, after the July deadline, or July 22nd depositions, which had been continued, counsel for Tillery Holdings sent multiple emails to counsel for Judge Holdings, making to the Tillerys available for personal deposition multiple times, and those were never taken advantage of. We had requested that not only we make our witnesses available for their depositions, but we wanted to depose the judge witnesses. On December 7th, 2021, counsel for Judge Holdings informed Tillery Holdings counsel that they would not make their witnesses available for deposition until after the Tillerys were deposed. So he wanted to make it a one-way street with regard to the depositions being taken. So the record does not support Judge Holdings' allegations that the Tillerys refused to participate and refused to be deposed. They had ample opportunity to depose the Tillerys and chose, for whatever reason, not to do it. I would also suggest, Your Honors, that the fact that they were not able to depose the Tillerys, it does not justify their motion under Civil Rule 56F. They had a burden when they filed that motion, and that burden was to point out specifically what types of evidence they were seeking by that additional discovery. They had to describe the nature and the type of the evidence that it sought through the discovery, and why it was warranted, why they needed that to respond to the summary judgment motion. They did not make any such specific reference in their motion. Rather, they indicated they just needed to depose the Tillerys to obtain information relating to all of the competing claims of the parties in this case. Well, the case law doesn't support that being a sufficient reason for a Civil Rule 56F motion. In fact, it indicates that you have to be specific and that you have to show why it's warranted. They didn't do that, so they failed the burden under Rule 56F. Now, they're alleging that this was an abuse of discretion, and I would submit to this court that it was not. In order for there to be an abuse of discretion, the Judge Holdings would have to establish that the failure to grant the Civil Rule 56F motion was improvident and affected a substantial right. Whether or not a substantial right would be affected would be determined if a trier of fact would have reached the same decision had the error not occurred. Now, again, you have to realize what is the ultimate issue here in this appeal or in this case, or with regard to the summary judgment. That's whether or not Judge Holdings timely closed the transaction and deposited the funds that they were required to under the purchase agreement. The only party that has the information on that is Rick Judge. The Tillerys had no information as to why he didn't deposit the money timely on or before October 4th, the expiration date for the cure period. Only Rick Judge had that information. Well, Rick Judge filed an affidavit in support of their motion for summary judgment and in opposition to our motion for summary judgment. So they had the opportunity through his testimony to explain why, in fact, he didn't timely submit the necessary funds and other documents necessary to close on October 4th, 2018. So we would submit that the depositions of the Tillerys, as sought by the Civil Rule 56F motion, would have had no effect on that argument. And the trier of fact would have come to the same conclusion, and there would have been no substantial right that would have been violated on behalf of Judge Holdings. And for the same reasons, if the court is of the opinion that it was error not to rule or grant the Civil Rule 56F motion, we would argue that that error was harmless. With regard to the ultimate issue of failure to cure the contract, based upon what Mr. Dodd had indicated, the notice of default was served on September 4th. I do want to point out the facts set forth in our brief that the court should be aware of, and that was the fact that the original closing date for the transaction was scheduled for March 31st, 2018. They had the opportunity to deposit, the initial deposit, earnest money deposit was $25,000. They could extend that initial closing date by depositing another $10,000, which they did, late, but they did. That extended the closing date to June 29th, 2018. Now, at that time, a total of $35,000 had been deposited into escrow. On June 30th, Mr. Judge lied to my client and said that he had deposited another $10,000 into escrow, thereby extending the closing date under the contract to July 30th. He never did that. My client believed him, but he never did. And the evidence is clear that he didn't. In fact, his own affidavit, I believe, admits that he did not. Then again, on or about August 8th, 2018, after the parties were discussing the fact that Mr. Judge couldn't close because his deal that he needed to close in order to close this deal wasn't going through, Mr. Judge lied for a second time and said that a third earnest money deposit had been set at $10,000. He even provided my client with a copy of a check. That was never deposited. So you have an individual who can't close this deal, and through his lies, he's trying to extend the closing date. Now, I point that out just because I think the court needs to know the factual background of how it ended up going to October. But again, the default letter was served on September 4th, 2018, requiring closing by October 4th, 2018. Now, Section 2B of the agreement required the balance of the purchase price to be deposited in cash in sufficient time to permit the closing of this transaction. It mandates the actual depositing of cash, not the fact that they would be ready, willing, and able to deposit the cash, but it required the actual deposit. Judge's counsel sent an email on October 3rd, the day before the 30-day period expired. He sent an email to Tillery and to the title company stating that they were ready, willing, and able. Now, the email to my client, Mr. Tillery, came in at 5:02 p.m. and the email to the title company came in at 7:30 p.m., well after business hours had been concluded. The next day, October 4th, the very last day to cure his default, he had indicated that he, again, was ready, willing, and able to deposit the money. Now, again, the language in Section 2B says that a purchase price shall be deposited in cash in sufficient time to permit the closing of the transaction on the closing date. Well, the closing date must have been October 4th because that would have been the last day to cure. This language implies, we would argue, an obligation on behalf of Judge Holdings to interact with the title company in order to determine exactly what amount needs to be deposited. They didn't do that. They had days, if weeks, if not months, to contact the title company and find out what the balance of the purchase price was. But they didn't do it until essentially the day of closing. And I would remind the court that the purchase agreement had a time is of the essence clause, which required them to cure this default within the 30-day period timely. They didn't do that. They were dilatory in their attempts to try to cure this, bringing this attempt to the very last minute and expecting everybody to be able to close in one day when they had to prepare a closing statement. They asked the title company to give information and instructions how to remove the exceptions to the title insurance policy. The closing documents had to be prepared. They were not prepared on October 4th, or at least they had not been circulated until the next day, October 5th, to Tillery Holdings. And that was a day after the 30-day cure period expired. So through their dilatory efforts, they didn't close and they didn't cure within a sufficient amount of time. Again, they didn't deposit anything. They didn't attempt to deposit anything. They never made any attempts again until the last day to figure out how much they were supposed to deposit. Now, they indicate that we refused to close. We did not refuse to close. We don't dispute the fact that the email that he refers to in the record exists. At that time, keep in mind, my client is of the mindset that he's been lied to twice and is not very happy. But that doesn't prevent the Judge Holdings from doing whatever they need to do to close the deal. And again, they could have found out days, weeks before what they needed to do, but they're waiting to the very last minute to try to do it.
Mr. Lane, your time has expired. Thank you for your argument.
Thank you.
If you'd like to move to your rebuttal, Mr. Dodd.
Thank you, Your Honor. At the beginning of Mr. Lane's argument, he referenced a discovery stipulations that were filed, resolving a number of the discovery motions. We don't dispute that. Our appeal doesn't relate to all of the written discovery, all the paper discovery, interrogatories, et cetera. It relates to depositions only. So the only subject matter of this appeal are those portions of the stipulations that specifically identified to the trial court what remained open and ripe for a ruling by the trial court. Counsel next asserts that his clients went to Bermuda because of COVID and issues relating to concerns for their children. Asserted that we knew when we scheduled depositions that the Tillerys were not available, that they had offered videotape depositions, and that a discovery dispute here had been manufactured. I would ask that the court review Exhibit B to docket number 106. That exhibit identifies the entire chronology of the back and forth, including every piece of correspondence relating to depositions. I would leave it to the court to decide whether or not a dispute was real or manufactured. With respect to the Bermuda trip, docket number 62 is the filing by the plaintiff requesting an extension of the case management dates and requesting that depositions take place by videotape. In that document, the correspondence from Tillery himself not only identifies that they would not appear for depositions, but specifically stated that they would not be coming back for the final pretrial conference or trial. With respect to the argument that we had enough time to depose them when they returned to the United States from Bermuda, they specifically said they weren't coming back. There is no evidence in the record that we ever agreed to continue depositions or conduct them another time. There's a reference that there were multiple emails about depositions that we never took them up on. I believe we responded to every single one of them substantively and took a position that was reasonable, and that is, since your client has defied 4 subpoenas and 2 deposition notices, we will gladly participate in depositions provided you give us a date and your client actually shows up and is deposed. Finally, with respect to the 56F motion, as we identified in our reply brief, appellee cannot make any such argument because it never opposed the 56F motion in the trial court. Therefore, it waived any argument that the 56F motion did not meet the applicable standard. The suggestions about Mr. Judge lying to Mr. Tillery are nothing but a red herring. Mr. Judge,
Mr. Dodd, I'm going to encourage you to wrap up because your time is about to expire.
Thank you, Your Honor. Mr. Judge doesn't dispute that he breached the contract by failing to close on time. What happened before then doesn't matter. The fact was Tillery had to provide a written notice of default and had to provide a contractual cure period. It did not do that. Thank you.
Thank you. Thank you both for your presentations. We will take them under advisement and issue a decision in due course. The clerk of courts will mail a copy of that decision to you on the day that it is released, and the opinions are also going to be posted on the Ohio Supreme Court website. Again, thank you very much for your presentations. The court is now adjourned until February 28th.